How much influence do creditors have in insolvency processes? The insolvency process of, say, a liquidation, the creditors have influence in terms of both appointing the liquidator and also to some degree what he actually does. So when creditors come to a liquidation meeting, the liquidator will have been appointed already by the shareholders. However, that nomination or that appointment needs to be ratified by the creditors. Creditors have rights in terms of how much they are owed as to how much they can vote for. So somebody owed £10,000 can vote for 10,000 for that 10,000 to put forward their point. Somebody owed 5,000 can vote for 5,000. So depending on how many creditors vote and how much they are owed, will depend on whether the incumbent liquidator, the shareholder's nomination, his position is ratified and he stays in office, or whether an alternative liquidator can be appointed. That doesn't stop there either, because if creditors believe strongly that there are matters that require investigation, they can request that a committee is formed, and that will again happen at the creditors' meeting. Creditors can put forward themselves or alternative parties to act on a committee of up to 5 members, and the committee, will help the liquidator to go through the investigation matters, the liquidator reporting back to the committee and deciding on what else needs to be done. And the other matter that creditors can be involved in is the actual resolutions that are passed at the creditors' meeting. To not only to do his job will he seek whether a committee is required or not, but he'll want resolutions concerning fees. So the fees of convening the meeting and the fees for doing the liquidation process. So creditors can say whether or not those are agreed or not agreed, or whether they should be amended in some way. So although creditors may feel they don't have any part to play, then quite often they do.